Good morning, everyone, and welcome to today's webinar, Year-End Reporting and Paying Dividends, Insolvency Considerations in Uncertain Times. My name's Adam Kutry and I'm a solicitor in Bartier Perry's Dispute Resolution and Advisory team. And we're here to talk to you today with BRI Ferrier about all things financial reporting. Before we get started, I'd like to go over a few items so you know how to participate in today's event. You may see on the right-hand side of your a control panel and a chat function. Throughout the course of today's presentation, if you wish to send in any questions, please feel free to do so, and we'll seek to address them throughout the course of today's webinar, time permitted, of course. Without further ado, I'd like to introduce you to today's speakers for this morning's presentation. Firstly, we'll be hearing from Paul Croft, a director at BRI Ferrier with over 20 years experience in forensic accounting, financial due diligence, financial reporting, and financial control and transformation. His career spans across leading global firms in both Australia's largest financial and education sectors. Paul is an expert in data analysis, financial modelling, forecasting, and structured operating models, and he'll give you some practical tips on how you can use financial modelling for your benefit throughout COVID times. After hearing from Paul, we will then hear from Phoebe. Phoebe's a commercial disputes lawyer with a particular expertise in insolvency advice and litigation. Phoebe has broad experience acting for both creditors, directors, and insolvency practitioners in all courts throughout Australia, and is Bartier Perry's most recent member to obtain a Reader's Advanced Certification in Insolvency. And last but not least, we'll hear from John Keenan, who's a principal at BRI Ferrier. John's a chartered accountant with over 20 years professional experience specialising in corporate restructuring for businesses in both growth and distress situations. John's experience extends from advising boards in difficult circumstances to taking control of businesses through appointments and voluntary administrations. I'll now pass over to Paul to hear about all things financial modelling.
Thanks for the introduction, Adam. And good morning, everyone. We all deal with uncertainty in our personal and professional lives on a daily basis. If nothing else, coronavirus has been a stark reminder of the growing role that uncertainty plays in business. It also serves as an extreme reminder of what happens when businesses and governments fail to adequately plan for unknown but potentially foreseeable events, no matter how unlikely the event. If you cast your minds back to the early days of the virus, our federal and state governments were consistently issuing conflicting health and safety messages. New information was emerging at such a pace, often making the previous day's announcements redundant. And with the 24/7 news cycle constantly reporting the bad news that was coming out of Europe, the UK and the US, there was this pervading sense of what is happening at the moment, and a fear generally held that Australia's trajectory could possibly be similar to that being experienced overseas. My partner is in education. Prior to schools closing, when many of us had already moved to working from home, he and his colleagues continued to front up to school daily without any PPE, putting themselves at risk. At home, he would come back and talk about the day's events and express his frustrations. As I listened to him, it became clear that one of the sources of his frustration was that he didn't have the tools or experience to guide him on how to operate effectively in a period of heightened uncertainty. And he didn't really know how to be confident about taking decisions when using imperfect and constantly shifting data. In response, his anxiety levels increased, and the way that he interpreted decisions that were being taken by the school's executive were often clouded by emotion rather than being guided by logic and common sense. There is no magic antidote to uncertainty. Today's interconnectedness means that the moment we solve one problem, a whole new world of possibilities emerge. But we can develop habits and apply simple frameworks that help us better manage uncertainty. And today I'm going to discuss such a framework that helps us build those habits, specifically in the context of avoiding situations where paying a dividend might affect the company's solvency. The framework incorporates my learnings from working on investigating insolvent trading actions, and including specifically the legislation I'm going to look at today, data gathered from interviews with senior finance executives and directors on what they're doing to better manage uncertainty in their financial projections, and my experience in building forecast models. Now, one more thing before we jump into it. There is no one-size-fits-all solution to managing uncertainty, and not everything I say today will necessarily be relevant to your business or your circumstances. So all I do ask is that you keep an open mind, discover what resonates with you, and then adapt and use the tools and techniques that you think might be a good fit for your business. So let's get stuck into it. About 10 years ago, a company's powers to pay dividends was changed under amendments to Section 254T of the Corporations Act. As it stands, there are now 3 conditions that must be satisfied before a company can pay dividends. Firstly, its assets must exceed its liabilities before the dividend is paid, and the excess is sufficient for the payment of the dividend. Secondly, the payment of the dividend is fair and reasonable to the company shareholders as a whole. And thirdly, the payment of the dividend does not materially prejudice a company's abilities to pay its creditors. Given the insolvency flavour of today's webinar, I'm going to be focusing only on the third limb. Unfortunately, the legislation isn't particularly helpful when it comes to explaining what is meant by the term material prejudice. As the phrase is a legal, not an accounting term, and the courts have yet to provide clarity as to what it means, there's nothing really more I can say on this. But the writers of the legislation were, however, kind enough to give us an example, with material prejudice said to exist where a company becomes insolvent because of the dividend payment. You might have to excuse my cynicism here, but it seems to me that the people who drafted the third limb loved ambiguity and uncertainty. The third limb kind of reads like an insolvency test, that is, the ability of a company to pay its debts as and when they fall due, except there is no explicit requirement that creditors must be paid as and when they fall due. In fact, the third limb provides no guidance whatsoever as to what future period directors must consider after paying the dividend in order to satisfy their obligations under Section 254T. On the one hand, given the diversity in nature of businesses, it makes no sense to draft legislation that is overly prescriptive. But on the other hand, should an insolvent trading action be brought against a director under the third limb, it's entirely feasible for an argument to be fashioned asserting that the directors failed to satisfy their obligations under the third limb because they did not consider a sufficient period of solvency after the payment of the dividend. Unfortunately, there is no simple answer to the question you might be asking yourselves, which is, what should an appropriate forecast period be? However, there is a way of thinking about uncertainty that may help. To do that, let's first consider the following timeline of events. The company prepares its draft accounts on 31 July for the June 2020 financial year end. Using a 3-way financial model, that is a balance sheet, P&L and cash flow, they prepare an 11-month forecast to June 2021, which is finalised on the 1st of August. The draft financial statements, together with the forecasts, are included in the information that are provided to the directors for their board meeting on the 15th, and on which they rely to declare a dividend on that date, which will be paid on the 15th of October. A simple way of thinking about uncertainty is categorizing between what is probable and what is possible. I tend to think about probable in terms of being able to use historical experience to predict an outcome with a reasonable degree of accuracy. In this example, the director's decision to pay a dividend was based on a forecast period from the date of declaration to the date of payment of a little under 3 months. I also tend to take the view that the future starts becoming much less predictable after about 3 months. And this is due to a number of different factors like the pace of change and the ambiguity and volatility that's present in today's operating environment. Accordingly, I generally consider that forecasts prepared for periods that exceed 3 months to be more in the realm of what is possible rather than what is probable. What this example is designed to highlight is that the outcome up to the dividend date falls within that land of of the possibilities. That is, it can be most likely be reliably predicted, but for any exceptional event occurring in that time, of course. However, beyond the dividend payment date, the future becomes increasingly less certain. Yet, as directors, you will need to factor that uncertainty into your decision about paying a dividend. As it shows in the slide, you don't know, is that period 3 months, 6 months, 12 months? So the question then becomes, how can we better manage uncertainty? Through experience, I found that the answer to this question lies in the art of knowing how to ask a different set of questions. As we know, approaching a question or a problem from the same perspective usually returns a fairly predictable response. So often it takes thinking about the problem from a different perspective through someone else's eyes to give you that brand new insight. As we step through the framework, I've included examples of questions that senior finance execs and directors are currently asking themselves to better inform their decisions about the future, to provide that different perspective, particularly as the businesses emerge into a post-COVID world. So let's get stuck into the framework. Since the first step in the framework is looking at the current state. So since restrictions were imposed, companies have taken the steps to right-size or steady their businesses, minimize cash outlays, mothball certain aspects of their operations, or for those fortunate enough, capitalize on emerging trends. With restrictions beginning to ease, now is the time to pause and take stock of where your business is today and reflect on the recent trends and your recent business experience. So some of the current issues that businesses are facing from people I've spoken to and what I've seen in the market. For those who have an online presence, they're now questioning whether that shift in consumer behaviour is a permanent shift or whether it might moderate over the short, medium or longer term. For some businesses that operated on a just-in-time basis, they were caught short when the domestic and international border restrictions were imposed, which interrupted their supply chain. For those businesses, they're now looking at ways to either secure future supply or put in place steps that will avoid future disruptions. And as many businesses have been doing over the past couple of months, they're looking at ways they can actually build up or shore up their cash reserves to ensure they can transition to the next normal. And if not, if there some businesses that are a bit unsure about that, they are considering now what additional steps they may need to take to ensure their businesses can withstand future economic shocks, such as those that might come from a second wave. If the first step's all about the present, the second step in the framework is really about looking to the future. This is where we've taken stock of the current state, and now we're going to actually shift our focus to thinking about what could potentially happen in the future. And in uncertain times, it's really critical to think more about the range of possibilities rather than coming out with a forecast that's going to result in an accurate prediction. The point of the second step in the framework is largely to surface the possibilities that allow businesses to take decisions and implement appropriate strategies under the more likely of the scenarios that you might come up with. So some of the forward-looking questions businesses are now asking themselves are, to what extent is social distancing permanently going to change customer behaviour? What happens if flexible work arrangements are broadly adopted across businesses in the CBD? What might this mean for landlords? And importantly, does the customer still sit at the centre of what you do? Excuse me. And over the past few months, governments have been demonstrating their willingness to intervene in markets to protect their economies. So could this foreshadow a greater willingness in the future to step back into the markets, to maybe attempt a bit of re-regulation of certain industries or sectors? There's been a broad consensus about a second wave or a second peak will occur. Question is now how and when might this second wave hit, and how deeply might this second wave hit? And then also really important is how, developing, I guess, the possibilities of how your sector might rebound, plus those that are adjacent to you and on which you rely. So we've actually started collecting, the first two steps have collected a lot of the information. Now the So that's really designed to generate high quality, insightful information about your business and the associated trends that you can now incorporate into your forecast models. So I've divided this step into two parts. The first part is the land of the probable, which takes a very tactical and very operational perspective. The objective of the forecast, the land of the probable forecast, is really to generate time-critical information that identifies risk, enables rapid decision making, and enable the business to quickly respond to unexpected shocks. Accordingly, there is a very strong P&L and cash flow focus on these forecasts, and they are best done with rolling four-week forecasts and 13-week forecasts at the upper end, constantly updated as new information becomes available. The second part of this step is really what I'm calling the land of the possible, which takes a more strategic view with a stronger focus on resource allocation, reviewing investment decisions, potential asset impairments, liquidity, and balance sheet resilience over 6 and 12-month periods. The fourth step is the one where, being the data nerd that I can be sometimes, this is where I think it gets a little bit more fun. But firstly, allow me to preface this step with the following statement. It's a very challenging time to be paying dividends. However, if after working through the first 3 steps, you remain confident that paying a dividend will not give rise to an insolvency event, then the final step in the framework is particularly important. Overlaying scenarios and using what if and sensitivity analysis are effective tools for testing balance sheet resilience, deepening your understanding of the business, and beginning to shape your view on the company's ability to pay a dividend without material prejudice to creditors. Some of the scenarios I know are being used at the moment. For those businesses that might have significant foreign exchange risk, they're looking at what rate must the Australian dollar depreciate to that could eliminate trading margins, reduce cash resources to critical levels, and potentially compromise the company's ability to pay the proposed dividend. Alternatively, at what interest rate might your business risk breaching its debt covenants, which could then trigger a default, potentially leading to an insolvency event. Third one is, if restrictions were to be reimposed due to a second wave, what drop in demand could your business sustain before solvency becomes an issue? And the last one potentially is, what happens if a key supplier or key suppliers cease trading? So by answering these questions, you'll be able to come up with not only what happens if, but you're able to start thinking about mitigation plans should those events occur. As I suggested at the very start, the scale, nature, and complexity of your business will determine which aspects of the framework might be relevant to your business. But at the end of the day, irrespective of the decision that you make about paying a dividend, I trust that the framework will yield some great insights about your business that you can develop into strategies to more confidently navigate an uncertain future. Thank you very much. And over to you, Phoebe.
Well, good morning, everyone, and thank you for joining us today. As most of those people in the audience will know, running a business is hard, and in these uncertain times, it is made even harder. I was recently reading an article from Dynamic Business, which provided intel from a survey of 500 SMEs about their current and future concerns, and of particular interest were the following 5 points. Only 22% of SMEs are confident in the state of their business right now. Less than a third of SMEs are planning for any growth over the next 12 months. The biggest concerns over the next 12 months will be profitability, managing cash flow, and attempting to grow their customer base. More than half of all businesses surveyed are relying on the injection of personal funds into the business to see it through the COVID-19 period. And lastly, 47% of SMEs were finding it difficult to recover unpaid invoices. Based on this, it is clear that for these SMEs, every day they open their doors, the company puts its capital at risk. Prudent directors often rely on detailed forecasting techniques to better inform themselves about the future financial position of their company. Yet, despite their best efforts and planning, Australian insolvency law provides for personal liability for directors in circumstances where they allow the company to continue to trade whilst insolvent, or to become insolvent as a result of the incurring of a debt in the event it is subsequently placed into liquidation.
So Phoebe, I might just stop you there. There's some pretty telling figures there coming from that article, and Paul mentioned a number of safety nets that businesses can put into place. What happens in circumstances where a director has incurred a debt and the company is subsequently placed into liquidation?
Well, generally, the liquidator appointed to the company will seek to recover against the director personally compensation in the amount of the debt paid, provided it was paid at a time when the company was insolvent. Much has been written recently about the COVID-19 safe harbour against insolvent trading, which was introduced by the government to ease the burden on directors during these times. However, that being said, there are still a number of general obligations with respect to directors that still apply. As you mentioned earlier, Adam, today I will be briefly considering the director's obligations with respect to declaring and paying dividends and how COVID-19 impacts this, as well as whether these are affected by the insolvency moratorium. And I'll also be considering the potential consequences for personal liability for directors with respect to improperly declared or paid dividends in the event that the company is subsequently wound up. The payment of a dividend at a time when a company is insolvent, or if the company becomes insolvent as a result of the payment of a dividend, can expose the director to personal liability, just as if the director incurred a trading debt at a time of insolvency in the event that the company is subsequently wound up in liquidation. Given the financial pressures on businesses and the shifting economic landscape resulting from COVID-19, directors should exercise particular caution when assessing the future financial position of the company in terms of declaring or paying a dividend, so as to avoid the potential for personal liability. As Paul discussed, many companies have in fact reassessed their financial forecasts due to COVID-19, and as a result have withdrawn or suspended the payment of dividends to preserve capital or cash. Paul has provided a number of useful practical tips for directors to use when assessing the future financial position of the company and declaring dividends in this regard. The legal considerations that directors should keep in mind when considering declaring or paying a dividend are set out under section 254T of the Corporations Act. Now, this section imposes a prohibition on the payment or a declaration of a dividend unless certain conditions are met, and is otherwise referred to as a three-limb test. Firstly, the company's assets must exceed its liabilities immediately before the dividend is declared, and that excess must be sufficient for payment of the dividend. Secondly, the payment of the dividend must be fair and reasonable to the company's shareholders as a whole. And lastly, the dividend must not materially prejudice the company's ability to pay its creditors. And unless those three limbs can be satisfied, a company cannot lawfully declare or pay a dividend. The directors must also be satisfied that the company has sufficient profits and that any additional requirements imposed by the company's constitution with respect to dividends are met.
Phoebe, I might just interrupt you there. I've got a question that's come through the chat. It's just asking whether or not you can go into a little more detail as to what each of those tests mean from a practical perspective and what a liquidator might look at if they're subsequently appointed.
Sure. Well, as I said, there are 3 limbs that the court will consider. The first limb under section 254T is often referred to as the net assets or balance sheet test. And this test involves, quite simply, the measure of assets over liabilities. Under this test, the amount of any excess of assets over liabilities is the maximum amount of any dividends that can be paid. Compliance with this test can be evidenced by reference to the company's financial records, which are required to be kept under section 286 of the Corporations Act. In terms of timing, this test must be satisfied. That is, the company's assets must exceed its liabilities immediately before the dividend is declared. And moving on to the second limb of section 254T, payment of the dividend must be fair and reasonable to the company's shareholders as a whole. And to the extent that there are different classes of shareholders within the company, this section requires that there be fairness between the interests of those differing classes. And the company must ensure that this test is satisfied at the time of payment of the dividend. And lastly, under the third limb, a company must not pay a dividend which would materially prejudice its ability to pay its creditors. For example, payment of a dividend would cause prejudice to a company's creditors if payment of the dividend would cause the company to become insolvent. Now, relevantly, the company is insolvent if it cannot pay its debts as and when they fall due. This test must be considered and satisfied as at the time of payment of the dividend. Now, in addition to the 3 limbs under section 254T, there remains the general overriding requirement under common law that a company must have sufficient profits before the declaration or payment of a dividend can be made. And this is also known as the profits test. Directors should refer to the last audited financial statements or management accounts of the company prepared in accordance with accounting standards to ascertain the company's profits. And last but not least, it's important to ensure that any additional requirements with respect to dividends imposed under the company's constitution are also met.
Thanks, Phoebe. Now that we know what the considerations are that you should look at prior to distributing dividends, what are some of the potential consequences that directors are faced if they don't comply with 254T?
Well, there are serious ramifications for directors, and the risk of these occurring is made greater with COVID-19. The obvious effects of COVID-19 is that it is likely going to have adverse financial effects on many businesses. These effects might include reduced revenue, loss of customers, the loss of contracts, reduced demand for services, particularly with respect to office amenities, with more and more staff working from home, an increase in debts that are no longer recoverable, a change in consumer demand, or a change in the way business is conducted. For example, the increased use of video conferencing and other online platforms, such as today's seminar. Now, when deciding to pay a dividend, directors will not only need evidence to satisfy the net asset test at the time of their decision to pay the dividend, but they'll also require sufficient evidence that payment of the dividend will not materially prejudice the company's ability to pay its creditors at the time when the dividend is ultimately paid. Now, in practical terms, this requires the director to attempt to anticipate the future financial position of the company, which may be proven to be quite difficult in the current climate, given the volatility of the economy at the moment. The period and extent to which COVID-19 and its effects on businesses will go on for is anyone's guess at this stage. No one knows whether Australia will be the subject of a second COVID-19 wave or whether we'll fall off the economic cliff, which according to Deloitte is only 100 days away. And when it happens, it'll be like pulling the tablecloth out and all of the plates falling and smashing to the ground. From an insolvency point of view, the true economic impacts on businesses are likely to be shown over the next 6 to 18 months, remembering that assistance from landlords and the government is by way of deferral only, and debts continue to accrue on the balance sheet, becoming due and payable at some later point in time. Now, John will no doubt be happy as the ABC reports that ASIC has informed there will likely not be enough liquidators to deal with the number of COVID-19 related corporate collapses. Now, for those companies that, excuse me, cannot see through the COVID-19 pandemic and are wound up, the issue around a director's liability with respect to the declaration or payment of dividends may become an issue. Now, as we are all no doubt aware, there is a general obligation on a director to prevent insolvent trading by a company. And relevantly, a company is insolvent, as I said, if it cannot pay its debts as and when they fall due. This is principally a test of a company's cash flow. The payment of a dividend, and in some circumstances, the declaration of the dividend itself, is considered to be a debt incurred for the purposes of the insolvent trading provisions. In insolvency, a director will be personally liable for insolvent trading under Section 588G if they allow a company to pay a dividend at a time when it is insolvent, or if the company otherwise would become insolvent as a result of paying that dividend. If found guilty for insolvent trading, the director will be personally liable to compensate the company for the amount paid. I'm sure John will elaborate further on what the liquidator will look at when seeking to determine what the director knew at the time of the decision to pay the dividend and whether it was in fact reasonable for the director to pay that dividend. Whilst we note the government's introduction of the new COVID-19 safe harbour against liability for insolvent trading, this does not afford total protection. But generally speaking, in order to avail themselves of the COVID-19 safe harbour, the director must be able to show that the dividend was incurred or paid rather in the ordinary course of the company's business during the 6-month period commencing on 25 March 2020 and before the appointment of an administrator or liquidator. Whilst a director may seek the safety of the COVID-19 safe harbour, there are still a number of other general obligations that still apply with respect to directors. The director must still be thinking about doing things in the best interests of the company and acting with care, diligence and good faith. Now, a failure to comply with these obligations may give rise to a separate cause of action to the liquidator outside of the insolvent trading claim and for which there is no temporary relief. We recently held a webinar on directors' duties and the COVID-19 and general safe harbour provisions were explained in some detail. If you're interested in receiving a copy of the recording or notes, they are available on our website. And with that, I'll now pass it over to Adam and John. Thank you.
Thanks, Phoebe. John, you mentioned on LinkedIn the other day that the economy is about to fall off the cliff. I might pass it over to you to talk a little bit more about that and what you're seeing in the market from the liquidator's perspective.
Thanks, Adam. And look, thank you, Paul and Phoebe. That was a really good introduction, good background on the issues, the law, and probably some of the models that directors really need to consider in this otherwise turbulent time. I've got to say, in reality, this discussion today is somewhat unique. Most businesses that I've been dealing with are, like you say, suggesting or feeling the impact financially of this last few months of COVID. from my perspective and our firm's perspective, we're a restructuring practice. So we're about trying to save businesses. And so I certainly hope there isn't a second wave, and that because we need a buoyant market, we need a buyer and a willing seller to be able to try and turn these businesses around. And in that common thread, which I think Paul and Phoebe have touched on, is the need to recapitalise a lot of businesses and recapitalise businesses in a safe manner. So this next 100 days is going to be interesting to see, and I personally think that the government may end up putting their hand in their pocket again and giving some additional support to some of these businesses to try and avoid that cliff that that graphic that we've got there showing. So look, today from my end, I'm going to be talking about the current market, about what I'm seeing at the board level, what people are sort of experiencing, and how, if a business was to fail after the event, what a liquidator might perceive as to the director's decision process, and if they did consider doing dividends. So look, most businesses are employing a conservative viewpoint. They're either cancelling or deferring payment of dividends at the moment to preserve their capital reserves. In fact, a lot of businesses are actually considering raising capital, that issue I mentioned a second ago about recapitalisation. The question is to do it in a safe manner at the moment. They're trying to maintain revenues or get them going again, where some businesses have actually just collapsed in revenues. And otherwise, there's just a push to reduce expenditure. That's supported in a large part by some of the government initiatives.
And John, from a raising capital perspective, are you seeing most of that capital being raised with private funds or people seeking bank finance? What are you seeing in the market from that point of view?
It's a combination of both. From the initial days where the government had encouraged banks to hand out what would be best described as sort of bridging finance or emergency funding up to 250K, that was difficult to come by. The banks were requiring, in the post, Hayne Royal Commission world, standard banking protocols, which is appropriate, but businesses weren't prepared or capable of providing that reporting immediately. So the PG requirements, or personal guarantee requirements, had become an issue for some of those directors. And so it's a combination of both debt and private equity. And I'll talk about it in a minute, it's different for larger companies versus small private companies. And I mean, what Phoebe's talked about a lot is about the small private companies who are feeling a lot of distress. The large ones are similarly doing so, but they've got the different element of the capital's coming from a separate source. And those parties are reliant upon, in some regards, dividends to stream income to those parties. So I'll talk about that in a second. And it's telling because, I mean, in early April, we would have seen that APRA released an announcement where they strongly encourage most of the banks to defer or reduce dividends to make sure that the banks, which are closely regulated as against most other businesses, which they don't have the insight into, to closely regulate and maintain their capital reserves. So that was probably much to the dismay of the retail mum and dad investor, but was probably a prudent approach taken by that regulator at that time. Now, not all businesses are struggling. Some businesses are doing great. I mean, supermarkets had an absolute boom, online businesses, logistics. My mother, who is older than me, has embraced online e-commerce for the first time. And that trend isn't going to go away anytime soon. So there's this generational change, and I don't mean that in the sense of the older parties getting involved, but there's going to be a change fundamentally in the way we do business. And so some businesses are doing really well. And I wanted to point that out because those businesses that are doing well, the consideration of declaring dividends may be a much easier conversation to have at the board level than those that, and I'll talk about in a second, are somewhat struggling. Now, there's also the flip side of that, and that is some of the smaller businesses are technically using dividends on a yearly basis as a means of distributing income to their owners and shareholders, where there's that privately closely controlled business. So there's two streams to consider here. There's the small, privately held, where really the dividends would be, by way of a better description, their drawings from the business and or payment of wages, management fees. And then you've got the larger separately controlled and owned businesses, which need to consider whether directors are independently appointed, and they have to consider the interests of shareholders. Now, when you consider those two different forms of business, I mean, there's probably three ways to generalize how they've been performing over the last few months. There's those that are strong, like what we mentioned there, those that are in the supermarket space or otherwise logistics, haven't had as much work ever in this period of time, which is great. So their reserves are probably strong, and their growth has occurred over the last year probably, and has been boosted in the last few months. There is also those that are in distress, and I've seen a lot of these of recent time. Those where the revenues, like in the retail trade, has collapsed over recent time. Their reserves have been dwindled over the last few months, and the relief that has been given by the government, which Phoebe's talked to about rental relief or the JobKeeper, that doesn't improve the position, that only mitigates part of the loss. If at best it might have a break-even position. The challenge is probably those that are, you could probably describe them as middling businesses, those that have been able to continue to perform or trade through, and they still have some reserves there, and year end's 2 weeks away, and they're considering their position for their shareholders. And that's probably the focus, I think, from my end of what those directors of those businesses need to consider. So I would think that they need to be looking at a deep dive into a financial model like Paul's described. No two businesses are the same. You know, the old three-way models, absolutely, but bringing to bear some reality into those models is important. And it's somewhat difficult right now to really predict what is going to happen going forward. Australia has done phenomenally well compared to, you'd say, the rest of the world from a health perspective in how we've done it. We've felt the financial impact, and we are now getting back up and running. And so I'm seeing a lot of businesses that are having a hard discussion with us at the moment, because they are starting to get back up and running, and those suppliers, those contracts that Phoebe had mentioned, have somewhat fallen apart over the last few months. The debts have escalated, and they are in desperate need to recapitalize the business to get up and running. So those businesses are probably more on the distress side of the spectrum than the middling, because they don't have the reserves right now to pay the dividend. Now, assuming those middling businesses have got those reserves and they do want to pay some dividends or declare some dividends, depending on how they're held, the government's given this COVID insolvent trading relief, which we discussed, which gives prima facie relief to the directors from declaring a dividend, because a dividend is a debt, and that is the ability through which a liquidator would recover it. The challenge is the way that the relief has been framed. It talks about debts incurred in the ordinary course, and like Phoebe mentioned, there's the director's duties that remain in place. So I guess and this is uncharted territory for everybody. There is no precedent case law here, and it's only going to be determined in fullness of time. But in a circumstance where a dividend was to be declared and the capital was returned, that money is no longer there for the business or for the creditors. And so I question whether the payment, subject to that particular company's circumstances, is a payment in the ordinary course. I think some boards would be pretty brave probably to consider that, given the unprecedented level of volatility that has impacted both, the top line numbers, and for some regards, I mean, ability to access finance. So I think it's going to be a little challenging. I don't have the answer on it right now. In many of my discussions, a conservative approach is what most boards are imposing. The other part to think about is, I don't want to get too technical about this, but there was a case called Mighty Rivers case there around the High Court, and what that case in essence said was, where there is distress and there is concern about the company's ability to continue to trade longer term, the going concern concept, those models that Paul talked about, then the directors have a duty to creditors and the creditors' interests. Now, failure to consider the creditors and returning capital, you can't unring that bell. You can't get the capital back. A liquidator can certainly try to by way of a recovery from the directors or otherwise, but it's something that the directors would need to consider at the time that they're forming these views as to declaring dividends. Because the flip side of this is that if it was to collapse, the liquidator comes along, we have the benefit of hindsight, which isn't always clear at the time you're making these decisions. So the onus is on the director to inform themselves of the full financial affairs of the company, consider claims, including those that are contingent creditor claims, and to ensure that there's sufficient headroom after that return of capital to be able to discharge your creditors, the third limb test that Paul talked about before. And I've got to say, as always, seek appropriate advice. This is basically the background to the safe harbour provisions, which is what gives most directors comfort in the legislation, and now has just simply been almost mandated that every company is in the safe harbour around Australia. And it's not quite that to that extent, but that's the current COVID relief. So
John,
I'd say, if I could, it's important, and I've been talking to directors about this, is to consider documenting their decision journey when they're considering these sort of capital issues. It's very, very important. Sorry,
just one comment that came about. You mentioned, obviously, the liquidator has the benefit of hindsight, and that these are all issues which boards should consider to create sufficient headroom in their decision making and documenting things. Knowing that year-end reporting is coming up now, what other observational tips can you give to directors so that they can try and avoid any claim later on down the track for a insolvent trading claim or a recovery of a dividend claim?
Yeah, it's a good question. I mean, Paul's little timeline that he set out there below. I mean, 2 weeks to year end, accounts generally prepared in the next 2 months. This is right in the middle of COVID, and so robust and honest models of the financial position is important. I mean, recently the government announced a relief against the continuous disclosure requirements for listed entities, and in a lot of companies, a lot of boards, this is obviously the larger reporting boards we're talking about here, have withdrawn their guidance as to future profitability. I think it's going to be interesting to see how those boards consider, if you're ignoring just future guidance. I mean, you've got an audit report that's coming up, you've got an audit opinion, and you've got to satisfy yourself as the going concern concept, and the directors have got to sign off to that. There's issues of asset values and impairments in circumstances where I know a lot of businesses are going out of their way to not value assets at this time, given that this is a blip, if you will. Valuing it at a snapshot in time could create some quite scary results on a balance sheet. And that obviously has an issue, a resulting effect on that first limb test, that net assets test, where obviously that surplus is relevant to the decision as to declaring a dividend. I mean, I can think of intellectual property or goodwill as being a very interesting asset to value in this current time, let alone perhaps lease incentives or otherwise. So I got to say, showing some restraint in declaring dividends would probably be relevant, unless those reserves on the balance sheet and the forward forecasts are really robust, I got to say.
Yeah, that's interesting. Obviously, from a litigation space, we've seen an increase in class actions and D&O insurance issues. We've seen the government announce some relief for board-listed entities on continuous disclosure obligations. How do you think it's going to play out for the more smaller privately held companies that Phoebe and Paul were talking about, who are probably more middling than those larger entities?
Yeah, it's a good question. So those businesses are run differently per se. So the dividends generally aren't considered by an independent board for the needs of forward forecasts for independent shareholders. They're generally determined after the event based on a journal entry, having the financials prepared. Those financials could be prepared 6, 8, 9 months later. Now, that's not the way the law reads, but that's probably what happens in practice. And the directors then sign off on a declaration on a special purpose set of accounts that says that the company was solvent or could pay its debts as it fell due, and it satisfied the going concern, and it was in a position to declare those dividends then. What the challenge is they're not done contemporaneously, and I think it's going to be telling for businesses that are doing those sort of declaration of dividends what happens if they do fail after the event, because it's near on impossible to really determine what's happening in 2 weeks' time, in 9 months' time. The facts aren't contemporaneous with each other. So what we're seeing is, what happens is the businesses, they distribute the money. Money usually goes through as loans to the respective owners, who are largely the directors of those businesses or closely held. And what we might see is a tendency to employ more wages or management fees as expenses, as a means of streaming income rather than a declaration of a dividend. That's just from my experience, what I've seen, where I've actually had them on jobs that I've got where the businesses have failed, and it wasn't orchestrated, it wasn't planned, it just unfortunately got away from a couple of the directors, and this happens sometimes. And they'll seek to retrospectively recreate a set of events or facts. So they might seek to back charge expenses or costs. And what this is a means of is either one, defeating a claim in respect of money having already been distributed to those parties, or really to try and stream that income. And so that sort of mentality with those closely controlled companies, I think we're going to see it more happening going forward, because a lot of those privately owned, they are reliant upon that income, whether it's dividends, wages, or management fees, for their livelihoods. And people are struggling. So where there's a need, there will always be a driving force to cause money to move. So look, if I was to try and look forward, I would think that a lot of businesses that are, especially in that middling ground, distressed ones just not going to have the capacity to do it, but in that middling ground, they will probably defer payments of dividends in 2020 if they were to be prudent, and maybe look towards that sort of a payment of capital, if you will, in the late calendar 2020 year, or possibly into the 2021 year, trying to give the economy some time to return to normalcy. I mean, you think about Alan Joyce in Qantas right now, they're actually in a much stronger position than Virgin, but if they were to return a whole heap of capital now, where they're going to be coming into a new market, which is going to slowly creep back in, they'd be pretty brave. So look, in short, I would, where there's uncertainty and concerns of financial distress, I'd probably urge conservative approach and maintain reserves wherever possible.
Perfect. Well, there you've heard it, people, from the mouth himself, John. Be conservative in these times and hold off if you can until late 2020, but take heed of Paul's advice and get your reporting right. Firstly, I'd like to quickly thank each of our speakers today for a very informative session. I know I've learned a great deal. If you do have any questions following today's session, please feel free to give us a call, or alternatively send an email to the relevant speaker. I know that we have had one just come through, but unfortunately we've run out of time to have that answer, but I will forward that on to the relevant person to come back to you on. Just following this seminar, you'll also receive a short survey. If you could all take a couple of minutes to fill that out, that'd be greatly appreciated. That helps us tailor our presentations to you for what you want to hear and what you think will be beneficial. On behalf of Bartier Perry and BRI Ferrier, I'd like to thank you for attending today's webinar. I hope you stay safe and look forward to speaking with you again in the future. Bye-bye.